for a will to be valid, you need it to be in writing. It can be handwritten. That's called a holographic will. But sometimes people think that they can line out things, like they had a will typed up years ago and they're deciding they don't want to pay an attorney to fix it, so instead they're just going to write their changes and sign and date. It's not quite that simple. Interlineations and things like that can actually invalidate a document or just not matter depending on where you write them. So it doesn't need to be typed or computer generated. If it's a holographic will, of course, it's important to remember that you need to be legible, right? Your handwriting needs to be legible. Other requirements are, there needs to be certain number of witnesses, notaries required. The legal requirements do depend on the jurisdiction, so I'm not going to lay them out here because it depends. But it's really important. Some people think that handwriting a little quick note saying like, I intend this, and I saw one like this recently, so that's my inspiration. I intend this to be my will. I want everything to go to my brother, John Smith, and then sign, date, and think that that's a valid will. That's incorrect, right? So you need to make sure, even if you're not working with an attorney, because an attorney's signature is not essential for a will to be valid, but the other legal requirements need to be met. So like different states have a different number of witnesses. Maryland, Virginia, and DC all require 2. And the witness, you would want to make sure it's not an interested witness. So in certain jurisdictions like DC, if you have someone who is interested in your estate serve as a witness, that can actually make it so that they don't inherit what you listed in the will. So I'll just give you a quick example. In DC, if you have 3 children, and you decide you want to leave 75% to one child, let's say, and then the other amount split between the other 2 children, and you have that child that's set to inherit 75% of your estate serve as a witness, that's what we would call an interested witness. Mm-hmm. And in DC, because of that fact that they witnessed your document, they will not get the 75% you laid out. Instead, they would get what they are entitled to, in my example, 1/3 of your estate under the laws of intestacy. So I can't stress how important it is to make sure you don't have interested witnesses. Some states require the notarized witness affidavit and things like that. But again, you would want to make sure that you know the requirements before writing your will.